All right, let's take you back to Bloemfontein, where Erin Bates is standing by. The Nulane accused, maintaining that they have no case to answer and therefore have filed a Section 174. Erin, what are we then likely to hear as these accused are seeking a discharge of this matter?
Yes, well, all but one of those accused tomorrow, through their legal representatives, the defense attorneys and advocates in this case, will be motivating and driving the position that the state has built no case against the accused in this first state capture matter brought by the ID of the NPA. We will have quick submissions in oral proceedings in the High Court tomorrow from 9:30 before Acting Judge Nompumelelo Gusha. And that's because during this week adjournment, we've had paper submissions, so heads of argument, at least from the applicants for those 174s, to be relieved of their criminal charges and walk free rather than head into a possible sentencing in orange overalls. Those are going to be heard tomorrow in the High Court, and then it's very likely that Acting Judge Nompumelelo Gusha will adjourn without making a decision and will provide that down the line.
So, Michael Merchant and Henny van Vieren penned an opinion piece around the crisis at the NPA and how they've failed. And part of what they're saying is that this Nulane matter was part of the case that would have assisted South Africa in extraditing the Gupta brothers to come and answer for what is now known as state capture in the country. Does this Section 174 affect them in any way?
Possibly. We will have to wait and see. Of course, the state still believes that it has a very strong case here, and even after Gusha last week scrapped some evidence she'd provisionally allowed in court on the understanding that it would be justified or kind of underpinned, undergirded by the testimony of witnesses the state brought, is off the table. There are those in the ID of the NPA and indeed the mother body of the prosecuting authority who believe there is a winnable case here. And quite right of you to underline the point that the extradition of two of the Gupta brothers, who were arrested in Dubai in the middle of last year by Dubai police, that's Atul and Rajesh Tony Gupta, their extradition hinges on the strength of the state's case in the indictment for this 25 million rand Nulane Investments matter. Now, some of the messaging we've had from the ID of the NPA before is that while this is chump change in terms of alleged Gupta loot, some 25 million rand, there is a strong chain of evidence here. We had testimony on banking records, including from Absa Bank, Bank of Baroda, Nedbank accounts as well, and some detail on what was happening inside the Gupta company Sahara Computers Group fleet of accounts within an Absa Cash Focus Group, which is an online banking service. And one of the Gupta brothers is on record as the managing person for that Cash Focus Group. An Absa witness described that as a super user for the Cash Focus Group. And so some of the monies which were allegedly looted from the Free State government for this high-level due diligence report were then paid into accounts at the Gupta Cash Focus Group. The counter to that is that this was all legitimate business dealings and that these monies were paid for intercompany loans and repayments. And so what will happen potentially if these 174s are successful is that the Guptas may then seek relief from their red notices from Interpol, that global policing body, by going to the Interpol officers directly. If they go to the Dubai authorities or the legal system there, they're unlikely to have much luck in getting any relief about this extradition, which is, we're told, in the pipeline and has been for almost 6 months, because in terms of red notices, the local jurisdiction or local authorities are not meant to look into the merits of the case. But this really is a do or die moment, not only for those 6 people and 2 companies accused who've appeared in the Free State High Court over weeks, but also potentially for those Gupta brothers who are sitting in Dubai and waiting for extradition or not.
So, I mean, what has brought us to this point in which you have reported on so well, Erin, is the fact that there was failure to manage a rudimentary part of this case, and that is the management of the chain of evidence, but also the authentication of those documents, which essentially is what those 3 are bringing to the judge to say, well, there is no case here to answer to. Shamila Patoy was at that transnational crime conference. Did she say anything about how they've handled this matter?
No, and in fact the position of the NPA is to not give rolling coverage. I think they're leaving it up to the likes of you and me on live cases. But Batoy at that transnational crime conference about combating transnational or sort of cross-country crimes, including money laundering, mentioned issues around the work of the NPA. In fact, at the beginning of her speech in Randburg on Tuesday, she said that it can sometimes be depressing how difficult it is to bring criminals to book. But in terms of speaking on Nulane, she would not be drawn on that. We do understand that the spokesperson for the NPA at large, Mthunzi Maga, will be in court tomorrow morning. But this really is a test moment for the ID of the NPA. Remember, the ID was established by President Cyril Ramaphosa as a temporary body, but was then made permanent. And when he announced it and announced the appointment of then head Advocate Hermione Cronier, he touted it as a special unit, an agile unit within the NPA to deal with state capture matters. And so I've spoken to some analysts who've said, we'll not throw out the baby with the bathwater here. If the state's case does crumble, firstly, that may not mean there isn't actually a case. It may just have been poorly argued and indeed investigated. But also that doesn't necessarily spell doom for other state capture matters in the pipeline. There could be lessons to be learned here on the part of the ID of the NPA. So tomorrow is really going to be a crunch day. And of course, it's also important to bear in mind that the nature of cross-examination, not least in a criminal trial, when a defense advocate or attorney's client is facing time behind bars, is going to be acrimonious. They're going to throw all their weight into ensuring that the state's case looks as weak as possible. And provided the state can prove on the documents which are before Gusha there was indeed a fraud between the Free State government and Nulane Investments, and that the financial flows which stemmed from that into the Gupta group were also dubious, it may have a winnable case here.
Right. Erin Bates, thank you tonight. I appreciate you, and thank you for coming on with us here on In Focus. By the way, we'll revisit that story once again in the next hour as we speak to Henny van Vuren, particularly around how the NPA has handled that case. He's written a piece alongside Michael Merchant and, of course, breaking down what went wrong and what could have been done right.